In different countries, there are different types of legal system. Some country practices a combination of two or more legal system. In contrast, some country practices only one type of legal systems. Malaysia practices the mixed legal system, which consists of written law, common law, and custom. This video will be looking into the written law. At the end of the lesson, learners are able to define law and sources of law, distinguish sources of law and its composition, and able to illustrate sources of law in Malaysia, specifically on written law. There are various definitions of written law. It can be deduced to law made by Parliament and any subordinate bodies in formal instruments being reduced to or is present in the written form. Written law consists of Federal Constitution, State Constitution, legislation, and subsidiary legislation. There are three branches in the Malaysian government: the legislature, the executive, and the judiciary. In Malaysia, both Federal Constitution and State Constitution exist and are in the written form. A constitution is basically the fundamental law of the land. The Federal Constitution is supreme throughout the land. As stated in Article 4, Sub-Article 1, this Constitution is the supreme law of the Federation, and any law passed after Merdeka Day which is inconsistent with this Constitution shall, to the extent of the inconsistency, be void. The Federal Constitution acts as a yardstick, which basically measures the validity of law. The Federal Constitution lays down the following. It establishes the form of government. It details the power to make laws, divides power between the state and the federal government, and it separates power between different bodies. The Federal Constitution of Malaysia is the principal legal instrument and currently has 183 articles and 15 parts. Each article in the Constitution has several sections that explain the guidelines and legislation for the interests of the people in details. The Federal Constitution is not cast in stone. Articles 159 and 161E states how it may be amended. It may be amended by federal law. In brief, there are four ways by which it may be amended. Amendments here refers to add or repeal provisions of the constitutions. The modes of amendments are: it must be supported at two-thirds by votes, and amendments requiring a simple majority. The amendment shall be made with the consent of the Conference of Rulers, and amendments requiring the consent of Yang di-Pertua Negeri of Sabah and Sarawak. The Federation is required to guarantee the sovereignty of Malay sultans in their respective states. Irrespective of whether it has a sultan as its ruler, each state has its own state's constitution. Still, for uniformity, all state constitutions must have a standard set of essential provisions. Hence, although the state constitutions are supreme in the respective states, still they are subjected to the federal constitution priority, because all state constitutions must contain some essential provision prescribed by the state federal constitution. The state constitution contains provisions that are enumerated in the 8th schedule. Legislation. According to Article 73, it states the extent of federal and state laws. Law legislated by Parliament will be at federal level, and it is considered as federal law. Law legislated by the state legislative assemblies is at state level, and it is considered as state law. The Malaysia practiced bicameral legislature at federal law and unicameral legislature for the state law. Parliament has the exclusive power to make laws over matters under the federal list, such as citizenship, defense, internal security, civil and criminal law, finance, trade, commerce and industry, education, labor, and tourism. Each state has legislative power over matter under the state list, such as land, local government, Sharia law and Sharia courts, state's holiday, and state public works. Parliament and state legislature shares the power to make laws over matters under the concurrent list, such as water supplies and housing. Still, under Article 75 provides that federal law will prevail over state law in event of a conflict. Listed are the federal list, these are the state list, and this would be the concurrent list. Parliament is the highest legislative body in Malaysia. It consists of His Majesty the King as the head of state, the Senate, and the House of Representatives. The legislative procedure or the lawmaking process of laws in Parliament is mentioned in Article 66 to 68 of the Federal Constitution. According to Article 61, Subarticle 1 states the power of Parliament to make laws shall be exercised by bill passed by both houses and assented by the Yang di-Pertuan Agong. Let us look at the legislative procedure of a government bill. The bill will be introduced by the minister responsible for the matter. At the first reading, in Dewan Rakyat, the minister will present the bill. At the second reading, each member of the Dewan will receive a copy of the bill. The minister will proceed with outlining the principle of the bill. The House will debate and be voted upon to proceed to the next stage. At the committee stage, the details of the bill will be further discussed. It is a fixed discussion, and at the end of the session, the minister will move the motion to report the bill to the Dewan, which is under the third reading. At the third reading, the bill will be reviewed again. Minimal debate and substantive amendment on the bill is no longer accepted. A vote is then taken, and if passed, the bill will be sent to Dewan Negara, which is Senate. At the Dewan Negara, the bill goes through the same stages: first, second, committee, and the third reading. Any amendments made to the bill will be returned back to the Dewan Rakyat. If there are any disagreement between the two Dewan, it will be resolved by the joint committee of both Dewan. After passing both Dewan, the bill is presented to the Yang di-Pertuan Agong for his assent. According to Article 66 of Article 4, the Yang di-Pertuan Agong shall within 30 days approve the bill, causing the public seal to be affixed. If the bill has not assented within the stipulated time, it shall become law after the 30 days has lapsed. Technically, after being assented, the bill becomes law. However, it will not come in force until it has been published in the Warta Kerajaan Malaysia. A bill legislated by the Parliament is known as an act. A bill can begin either from Dewan Rakyat or from the Dewan Negara. However, the process would be the same. The legislative procedure of state law is relatively straightforward. It applies the unicameral system. The legislator of the state consists of His Highness and Dewan Negeri, which is the legislative assemblies. The bill must pass the legislative assembly and assent by His Highness. The bill legislated at the state level is known as enactment or ordinance. Here are some examples of federal laws and state laws. Subsidiary legislation. It is defined in the Interpretation Act as any proclamation, rule, regulation, order, notification, bylaws, or other instrument made under any ordinance, enactment, or other lawful authority and having legislative effect. As the government business gets more complicated, Parliament and the state assemblies may confer or delegate their legislative power to administer to administrative bodies such as Yang di-Pertuan Agong, minister, or the local authorities. Let's look at the reasoning why the legislator had to delegate its lawmaking power. 1. Insufficient time to enact the details needed. 2. Legislation may sometimes be highly technical, hence it is best to leave it to the expert. 3. Subsidiary legislation is more flexible and required in legislating law regarding currency control, import duties, and many more. This is also allows the minister to act quickly, legislate or rescind impractical or outdated laws. Subsidiary legislation is also the right choice to legislate laws in order to cater to current needs to overcome unforeseen emergency events. Despite the ease in legislating the laws, it is imperative to protect the public from abuse of the administrative authorities. The main controls are judicial control, where the court have control through judicial reviews, consultation, enabling making prior consultation mandatory, publication, require publication mandatory, and non-compliance would render the subsidiary legislation void, and legislative control, where it imposes laying procedures, where the legislation be laid before the House in draft form. Here are some examples of subsidiary legislation. Take note of the terms order, notifications, and bylaws.